There are common myths about divorce that at Gotelee Solicitors we're asked about regularly. This video will help dispel some of those myths. Myth 1. He or she will get a reduced share of the assets as they were to blame for the breakdown of the marriage.
One of the things that I get asked quite a lot about is if I've had to issue divorce proceedings because my partner has behaved in such a way, will I get a fairer and more from a financial settlement? The short answer is no. It is only really in exceptional circumstances that the court would take into account bad behaviour of one party to justify a much more favourable settlement in one party's favour than the other. And because it's so rare, it has to be something that the court cannot ignore in terms of looking at a financial settlement.
Myth 2. He won't see the kids if he doesn't pay child maintenance, or she won't let me see the kids, so I'm not paying child maintenance.
It is the child's right to have contact with both parents following a couple separating or subsequently divorcing. Therefore, it is not correct to say that because one parent is not paying child maintenance for their child or children, they cannot spend time with them. Indeed, there are several cases where the maintenance may not be paid or indeed may be at a low level, and that's where perhaps the parent is unemployed or on state benefits. Therefore, in summary, the child has the right to have contact with both parents irrespective of whether child maintenance is payable or not.
Myth 3. I didn't commit adultery as we'd already separated but not divorced.
In English law, there need be no causal link between the irretrievable breakdown and the adultery alleged. The adultery is simply evidence of the irretrievable breakdown of the marriage. This means that even where couples may have separated several years previously, if one has commenced a new relationship, they are at risk of being divorced on the basis of their adultery, even if they separated several years earlier and the new relationship was in no way linked to the breakdown of the marriage.
Myth 4. He or she isn't entitled to my assets because they're in my sole name.
When people have been married for a long time, they may have assets in their sole name, but those assets are likely to be considered as joint assets and part of the marriage. People may have, for example, a pension scheme in their sole name, but that forms part of the pot for division on a divorce. For some reason, a house might be in one of the person's sole name, perhaps because the other person couldn't go on the mortgage. Again, particularly if parties have been married for some length of time, then that all forms part of the pot. The only time that assets wouldn't be taken into account might be, for example, if they've been inherited and kept separately, or particularly if people have only been married for a short length of time and they've managed to keep their assets separately and they're not needed to meet housing needs. But the primary concern when looking at divorce is to start and look at what's on the table. That includes all of those assets.
Myth 5. We divided our assets between ourselves and obtained our divorce and decree absolute from the court, so my ex has no financial claims post-divorce.
Whilst the divorce process legally ends your marriage, it does not legally end your financial obligations to each other. It is important to obtain a court order which includes a clean break provision which will prevent either party being able to make any more financial claims against each other at any stage in the future.
Myth 6. We've lived together as a couple for some time, therefore I have the same rights as being married.
People will come to see me and have a misconception that because they've been living with somebody for a period of time that they have gained rights. They believe that they are a common law spouse. In English law, that concept does not exist. Living together with somebody for a period of time does not give you rights to the other person's pension, and as an adult it also doesn't give you any rights for maintenance. What you might have, particularly if you have children, is an entitlement to child maintenance for any children of the relationship, and there may be some ability to have housing needs met for a period of time whilst the child is still a minor. But otherwise, unless you have made arrangements through joint ownership of a property, then you will not have any entitlement simply by virtue of living together. Really, you need to take advice from your solicitor who will be able to assist you in looking at the circumstances of your case.